What's the most common reason a DUI is dismissed? Well, the most common reason in my experience is the lack of reasonable suspicion necessary for the officer to administer field sobriety test. Let me break that down a little bit. You've probably been driving by, usually at night, and a police officer has someone pulled over on the side of the road, and maybe you've seen the officer doing this in front of the driver's face. This is what we call the HGN, or horizontal gaze nystagmus test. The officer is trying to determine if the driver has nystagmus in his or her eyes, which is an involuntary jerking. That's what they're looking for when they do this test. You've probably also seen where they have a driver walk down a straight line, turn around, and come back. Or maybe you've seen on the side of the road again or in a parking lot, the officer having a driver hold his one foot up off the ground. We call that a one-leg stand test. Those are all tests designed for the police officer to determine whether or not that driver is impaired. Now, it's not simple enough that the police pull you over and they can administer those tests. It's not that easy. They have to have reasonable suspicion to do so. So what is reasonable suspicion? Illinois courts don't have a one-size-fits-all definition of reasonable suspicion. But what the courts have said is it's more than a hunch. So what happens is that officer has to have more than a hunch of your impairment before he can administer those tests. So for example, if you get caught speeding down the road at midnight, does that give the officer reasonable suspicion to administer field sobriety tests to determine if you're intoxicated? Most likely not. What if you're swerving gently within your lane and it's midnight? Well, probably still not. But what if you're doing one of those two things or all the above, and the officer claims, at least in his police report, that he smelled the odor of an alcoholic beverage on your breath? Is that enough to get to reasonable suspicion of impairment or intoxication? Probably so. At that point, he can probably administer those field sobriety tests. Now, what happens when the officer doesn't have the requisite reasonable suspicion to administer the test? That opens up the door for a defense attorney like me to argue to the judge that that officer put the cart in front of the horse and administered those tests when he didn't have the requisite reasonable suspicion, and as such, all the officer's observations, the tests themselves, the result of those tests, etc., I can ask that all that be suppressed. In other words, I ask the judge to not allow the state to use that evidence in a trial. If you find yourself charged with a DUI, please call me. I can help you.